saving estate taxes and simplifying an inheritance are just a couple of reasons why people might consider adding an adult child to a property title. Erin Galhouse is an associate with Getz Collins and Associates. She joins us this morning to tell us more. Good morning, Erin.
Good morning.
So this can be a complex topic with a lot of things to consider, but can you just give us some reasons why someone might want to add their adult child to a property title?
Yeah, I mean, on its face, it may appear to have some benefits. It could enable your child to assist with arranging for the maintenance and paying bills associated to the property, should you ever lose the ability to do so. And what also seems to be a very hot button issue right now is that it could help you avoid probate fees. By putting your child on the title of your property, it would pass outside of the court probate process and not be subject to probate.
Interesting, but kind of sets us up for this next question of just what are the risks with making this type of move?
There can be some serious consequences involved with putting your child on title. First of all, I mean, it results in your child becoming the actual legal owner of the property. So this means you're essentially giving up control over one of your biggest assets. Any future sale or refinance of the property would require their consent and their sign off. It also means that your child could potentially secure debt or loans against the property. If they had any creditors, it allows the creditors to register judgments and liens against title. And even if your child doesn't have any, or they're not in any financial trouble right now, down the road, if they get into financial trouble, it could result in your interest in your property being seriously impacted. And thirdly, I mean, you might also be creating future litigation for your estate, especially if you have multiple children and you only put one of them on title. On your death, it could be unclear whether that specific child that you put on title was meant to inherit the entire property, excluding the siblings, or whether they were simply meant to manage the property, with it then being shared with all the children as joint inheritance. So this lack of clarity could result in a very contentious and expensive litigation down the road. And lastly, adding your child to the title can also carry significant tax consequences, potentially triggering capital gains or creating a gift for tax purposes. So it would be really important to talk to an accountant when considering that type of move.
Taking all of this into consideration, because yes, there's the pros, but there's a lot of other risks associated with this. Just what are the facts? Because I know people want to simplify their inheritance or maybe save on those probate fees. So what would you advise them in this situation?
Yeah, I mean, probate is very different in Alberta than other provinces. So in Alberta, fees for probate are paid out of the estate on a fixed schedule. So this means that they're actually capped at $525 for estates that are worth more than $250,000, and then it decreases accordingly from there. Other provinces actually have probate fees that are a percentage of the estate, so that's where I think it can get quite expensive. And then any type of transfer of title involves land titles fees, which are actually based off the value of your property. Land titles, the current calculation there right now is $50 base fee plus $5 for every $5,000 of the property value. So ultimately, depending on the value of your property, you may end up paying more than what the probate fees that you were actually trying to avoid in the first place.
Lots to take into consideration here. Thanks so much for this, Erin.
No problem.
Of course, for more information, head to GetzCollins.com.
Sponsored by Getz Collins and Associates, attorneys with modern ideas and old world values.